Greetings and welcome there, academic proletariat, to this short episode of the Fireside Chats with Mr. Olson, where we will be talking about influential Supreme Court cases in U.S. history. We're not going to talk about all of them, just some of the big, heavy hitters. Let's start by talking about some background regarding the Supreme Court. Not sure how much your class goes into the background of the Constitution, so I will tell you that the Supreme Court is established by Article 3 of the Constitution, and it has undergone various changes or attempted changes over the course of its life. We won't talk about those here. We're going to kind of go with its current form. So if you want to look into those, you can always visit other sources. Anyways, the purpose of the Supreme Court, or its job, is to interpret the Constitution. Basically, its job is to mediate between conflicts of other federal courts. So if a case starts in a lower court, is decided, and then decided differently in an appeals court, then the Supreme Court would make the decisions. It has on it 9 justices, 1 chief. They are appointed for life as to try and limit any political influence on them. After a case has been decided, the side with the majority, or the winning side, issues what's called a majority opinion. The losing side issues a minority opinion. I tell you that in case Supreme Court majority or minority opinion shows up on a DBQ and it's in the source information. Okay, we're going to talk about the Supreme Court cases with regard to who the chief judge was, or what the court was making the decision. There are 3 major ones that you need to know, 1 subsequent one, and then 1 that we don't have a person for. Okay, so we're going to start with the Marshall Court. This is arguably the most influential court in American history. He was chief judge for 34 years when the nation was kind of figuring itself out. So the overview of his court is like this. If you can remember that he's a Federalist, you are good. He wanted to centralize power. He promoted business enterprises, much in line with the King Federalist of them all, Alexander Hamilton. But he also saw federal laws above state laws. He wanted a stronger central government. So we'll see how that plays out in the cases that he oversees. The most important case in American history in the life of the Supreme Court is without question Marbury versus Madison. It's a case that is heard in 1803. It establishes judicial review. I'm not going to talk about the background of the case because it's much too messy for here, but we're just going to talk about the outcome. It establishes judicial review, in other words, gives the court the power to rule acts of Congress unconstitutional. That's what we see the job of the Supreme Court being today, and we don't realize that it essentially gave itself that power by the decision it made in 1803 with Marbury versus Madison. Anyways, we carry that forward to a Supreme Court case heard in 1819, McCulloch versus Maryland. Now, oftentimes, and this is for all my AP US government and politics people and teachers out there, oftentimes McCulloch versus Maryland is seen as the bank decision, the bank case, because the state of Maryland is ruled not to be allowed to tax a federal bank because a state could essentially kill that federal bank by overtaxing it. Anyways, Marshall is evoking the supremacy clause of the Constitution. The idea that the federal law is supreme over state laws. A state cannot overturn or overpower a federal law, and that's what's being evoked with this case. And then finally, another key Marshall Court case decision is Gibbons versus Ogden in 1824, which rules that the federal government has the power to regulate interstate commerce. One company wants control over a river that goes between 2 states, and essentially the Marshall Court says you can't do that. Federal government reigns supreme. Okay, so you see a thread being woven through those 3 courts. Right, we're going to move on to the sort of subsequent court, and it's the Tawney Court that rules for the 30 years or so after John Marshall is done. And Tawney is appointed by Andrew Jackson. He's a racist former slave owner from Maryland that some argue isn't a racist, but I'm going to tell you why he is in a second. He oversees the famous Dred Scott versus Sanford case, one of the major events that leads up to the Civil War. Dred Scott, a slave from Missouri, is taken to a free state, Illinois, with his master to live for a while. So when he gets back to Missouri, he sues for his freedom on the grounds that he was taken to a free state, and he should be deemed free now. He wins in the lower court, loses in the appeals court, so it goes to the Supreme Court, where Roger Tawney oversees a decision that says the descendants of Africans who were imported to this country and sold as slaves are not included and were not intended to be included under the word citizen of the Constitution. Basically, blacks are not citizens. It invalidates the Missouri Compromise, which is the essential piece of information you need to know for it, but also it basically makes every state a slave state because a slave owner can take his slave wherever he wants and for them to still be a slave. Kind of unfortunate right there, but one of those things that sort of certainly provides impetus to the Civil War. Now, lesser known cases, but still influential, occurred during the Gilded Age, and there's no really chief judge important enough to remember here, so I'm just going to kind of generalize it by saying that these cases supported racist ideals and supported big business. It's like America in a nutshell, if you will. The big business is best seen through what's called the slaughterhouse cases, which are a series of cases heard in 1873 that reinterpret the 14th Amendment, that one that's supposed to give people citizenship under the law. Anyways, the slaughterhouse cases say that citizenship rights are protected by the federal government, but state citizenship rights are not protected. So if the state passes a law to undercut your citizenship in that state, then you have no recourse. Kind of unfortunate there. In addition to this, Plessy versus Ferguson is also passed during the Gilded Age courts in 1896, and this, of course, famously rules that this guy right here should not be allowed on a train car, or at least on a white train car, because he's black. This guy right here. You see him? Right there, him. Okay? He's too black to ride with white people. Anyways, separate but equal accommodations were constitutional. Of course, this sounds good in theory. Actually, it sounds terrible in theory, but at the time it sounded okay in theory. But what happened was that there was not equality between the two facilities. Okay, we see it best with schools. Anyways, we're going to talk about more about that in a second. The next major court era is the Warren Court. Earl Warren, pictured right there. He oversees the court for roughly 15 years after World War II. His court, the overview of this is that he increases civil rights to people. He promotes social programs and establishes rights for the minorities, or for certain minority groups and suspected or accused criminals. Now, you'll note that his time as chief judge coincides with both the civil rights movement and the Great Society. So that's why he's overseeing these civil rights cases and these Great Society programs. The most influential Supreme Court case that he oversees is Brown versus Board of Education, which is heard in 1954. It overturns Plessy versus Ferguson and rules that racially segregated schools are unconstitutional. It says that a denial of public education is a violation of the 14th Amendment, and of course, some historical context for you here. It's met with massive resistance throughout the South, notably in Little Rock, Arkansas, where 9 black students are at first shut out from high school and then required the National Guard to bring them. That's another case that he oversees, and one that's not really mentioned that much, but I'm going to mention it because it's important with regard to the rise of new conservatives, is Engel versus Vitale, a case heard in 1962 that rules that mandated prayer in school is unconstitutional. This, of course, gets all the religious people throughout America, notably those in the South, all hot and bothered, that prayer is now not allowed to be forced on students in school. It gives rise to the angst of the silent majority who are overwhelmingly religious, but then also that super religious sect within the silent majority called the moral majority. We'll hear from them more in a second. Earl Warren also oversees a privacy case involving contraception called Griswold versus Connecticut that's heard in 1965. This is, of course, a precursor to Roe versus Wade, which we'll talk more about in a second, that proclaims a woman's right to privacy. It rules that a state law banning contraceptions is unconstitutional. You can't do that. And now to talk about the criminals, Gideon versus Wainwright is a case heard in 1963 that argues that this guy, who was arrested but not given a lawyer, was treated unconstitutionally because all suspected criminals have a right to legal counsel. So that means that if you get in trouble with the law, you have to be provided a lawyer to give you some sort of counsel or recommendations with regard to your rights. The second is Miranda versus Arizona, one that gives us the famous Miranda rights. It rules that suspected criminals must clearly be given or read rights before they're arrested or interrogated, so they know what they can and what they can say, what they can't say, what they are allowed to say, and what they're allowed not to say. Okay, and then the third court is the Burger Court, and the Burger Court is characterized largely by not living up to its intended ideals. So Warren Burger is appointed by Richard Nixon, who's elected largely by the silent majority, and we think that he is going to carry on a large of the conservative ideals, and he does not. So it leads some people in politics to criticize Nixon, not that they didn't already have enough ammunition to do that, but let's see what Burger does. Burger ends up carrying on a lot of the ideas that Earl Warren put forth. So in the case Swan versus Charlotte Mecklenburg Board of Education, the Warren Court rules that forced busing of children to achieve integration is constitutional. This, of course, sends white people into a tizzy, especially those in Boston, and it causes a lot of fighting there. But it's trying to promote civil rights. Then Roe versus Wade, which is the big granddaddy of them all with regard to giving rise to new conservatives, upholds a woman's right to have an abortion in the first trimester of a pregnancy. Now, this adds to the growing angst of the moral majority, already seen in Engel versus Vitale, already seen in Griswold versus Connecticut, and now it's like a full-blown war against the government. And then finally, the University of California versus Bakke is a case that upholds affirmative action, which is the idea that race can be taken into account when hiring or accepting people into positions, namely students into colleges and things like that. However, the court does rule that strict quotas are unconstitutional. I kind of ride the fence there, but they do extend rights to minority groups through the fact that race can be taken into account in applications. Okay, so there are some major Supreme Court cases for you, but there's one thing to keep in mind. The Supreme Court, one of the most conservative of government branches, just might, be under the control of somebody else. All right, that's all the time we have for today. Stay classy.